Welcome to Legally Speaking, your go-to destination for all things related to law. Whether you are a legal professional, a law student, or simply curious about the fascinating world of law, this is the channel for you. And I'm your host, Didal Loshkar, and I'm thrilled to be guide on this exciting journey. We're going to discuss about the topic adultery. What does adultery mean and different case laws of adultery? Adultery in India is based on the notion of patriarchy and male chauvinism. Means adultery is based on the patriarchy. What does patriarchy mean? Patriarchy means a society where there is male domination. And what does chauvinism mean? Chauvinism means which society which believes that men are better than women. The offense makes a man criminally liable who has relationship with a woman who is wife of another man. But if the husband consent or connivance to such act, it will be no longer an adultery. For example, a person, a male, and B, a female. B is wife of C. So A and B has a sexual relationship, but which C doesn't know. C doesn't have a consent or connivance. The sexual relationship between A and B is termed to be as adultery. C can prosecute A for the adultery. He is criminally liable for doing such act. I think you understood this offense. Section 497 of Indian Penal Code 1860 defines adultery. Whoever has a sexual intercourse with a person who is and whom he knows or has reason to believe to be wife of another man without the consent or connivance of that man, such sexual intercourse not amounting to the offense of rape is guilty of the offense of adultery and shall be punished with imprisonment of either description for a term which may extend to 5 years or with fine or with both. In such case, the wife shall not be punishable as an abettor. This means that, for example, A male, B a female who is wife of C. C is husband of B. If A and B has a sexual relationship which C doesn't know or she doesn't have a consent, and A and B both have consent, B also has consent of sexual relationship with A, which is not rape, not amounting to rape. For this offense, A will only be liable for the adultery. B will not be criminally liable for the offense. C can prosecute A for this offense, and which the imprisonment for this offense will be 5 years, which may extend to 5 years, or fine, or both. I think you understand. So let's discuss about the case laws, different case laws by different high courts and supreme courts. In case Yusuf Abdul Aziz versus State of Bombay 1954, Section 497 of IPC was challenged on the ground that it violates Article 14 and 15 of the Constitution. What does Article 14 mean? Article 14 means right to equality, which means equal protection of law and equality before law. What does Article 15 mean? The state shall not discriminate against any citizen on the ground only of religion, race, caste, place of birth, or any of them. It was challenged on these two grounds, Article 14 and 15. Why? Because it only prosecutes the male member who has a physical relation or sexual relationship with the female member. It doesn't prosecute the female. So what was the opinion of the High Court? What was the judgment? The three-judge bench upheld the validity of Section 497 of IPC, stating its special provision implemented for women under Article 15.3. What does Article 15.3 mean? Article 15.3 means the state can make special provision for women and children. So the court judgment says that this is a 497 is a section which is specially made for women. It's to protect the woman. So let's go to the next case law. In Soumitra Vishnu versus Union of India 1985, Section 497 was challenged on the ground that this provision does not provide the right to women to prosecute the woman with whom her husband has committed adultery, and hence it discriminatory. It means that if A and B are husband and wife, A is wife and B is husband, and X and Y are two person, whereas X is a woman, is wife, and Y is a husband. So if this husband make relationship with X outside the marriage, this is an adultery. But Y can prosecute B, but A cannot prosecute X. On this ground, it was challenged. What does the court said? Three-judge bench on this case upheld the validity by stating that extending the ambit of offence should be done by the legislature and not by the courts. The court said that this should be done by the legislature and not by them. Offence of breaking family is no smaller than breaking a house. The also court said that एक घर तोड़ना जितना बड़ा ऑफेंस है उतना ही बड़ा ये ऑफेंस है. So punishment is justified. The court accepted only man can commit such an offence. सिर्फ मर्द ही ये ऑफेंस कर सकता है, वोमेन नहीं कर सकता. In B. Ravati versus Union of India 1998, it only punishes the outsider who tries to destroy the sanctity of marriage. The court said that it punishes the outsider. Suppose A and B. B is outsider. A man who is outsider coming and breaking the marriage of X and B. Suppose X is a wife of B is a wife of X. X is husband and B is a wife of X. In B. Ravati versus Union of India, in B. Ravati versus Union of India, 1998, the court said that it only punishes the outsider who tries to destroy the sanctity of marriage. What does it mean? It means that suppose A, a male, and B, a female, who is wife of X. So he is an outsider coming and destroying their marriage between B and X. The latest judgment, Joseph Stein versus Union of India, under Article 32, Joseph Stein filed a PIL challenging Section 497 of the Indian Penal Code 1860 of being violative of Article 14, 15 and 21. What does Article 14? Right to equality, equal protection of laws. What does Article 15 mean? There shall be no discrimination on the ground of religion, race, caste, gender. And what does Article 21 means? Right to life and personal liberty. Protection of life and personal liberty. That no person shall be deprived of life or personal liberty except according to the procedure established by the law. What does the court said? What does Supreme Court said? The case was heard by constitutional bench, which includes CJ Deepak Mishra, Justice G.Y. Chandrachud, Justice R.F. Nariman, Justice A.M. Khanwilkar, and Justice Indu Malhotra. What does constitutional bench means? Constitutional bench means they have the same power as an amendment done by the parliament. On 27 September 2018, 5-judge bench unanimously struck down Section 497 stating it's an unconstitutional. What does the court said? Court said that on these three ground, Article 14, 15 and 21, it violated Article 14, 15 and 21, so it's unconstitutional. And adultery is no more now a crime and no one can prosecute anyone on the ground of adultery. But still this law exists in some cases. Exception to this law still exists in the army and it is termed as stealing the affection of brother, officer, wife. This means if an officer of the service is found guilty of having a relationship with wife of another officer, then court-martial proceeding can be taken against him. This offence is adultery is still a crime in the army. The SC had sought that the government opinion on the repeal of the law on behalf of 3 armies. The government says that the army should be kept out of the order 2019 because in their own rules adultery is seen as serious offence and those found guilty can be dismissed from the service. The the government said to Supreme Court that this should be still kept in the army because of their own disciplinary reason and in the rules of army this is still an offence, so it should be kept for the army. Thank you for listening. Thank you for being a wonderful audience, wonderful listener. Thank you. Please subscribe to the channel.